Good afternoon, everybody. My name is Brian Tully. Thank you for joining us once again for our Wednesday webinars here at Tully Law Group. Today, we're going to be talking about safeguarding our seniors, and we're going to get into 12 different strategies and topics on how to do that. But first, like always, we'll give it another minute or two for people to sign in. See you in a minute. All right, everybody, welcome. Again, this is Brian Tully, the founder of Tully Law Group. We are an elder care and an estate planning law firm based in Long Island, covering Nassau County, Suffolk County, folks in the city as well. Before we get started, I just want to make sure if you can just verify for me in the chat box or the Q&A that you were able to see my PowerPoint and you can see me and hear me and that we are ready to go. Usually it works out pretty good. We've always had minimal technical difficulties. So if somebody could just let me know we're good, that would be great, that you can hear me and see me. In the chat, please, somebody. Q&A. No? I know there's 15 of you out there. All right, very good. I appreciate that. All right, we're good. Thank you. We're going to get started. So again, today we're talking about safeguarding our seniors. As those that follow us and know us, I've been doing elder care work, estate planning work for 27 years. Yesterday was actually just an anniversary. First started back in 1998. And gratefully, our firm has grown to a point where we have a staff of over 26 folks really focusing purely on safeguarding our seniors through estate planning, through asset protection, care advocacy, government benefits, tax planning, and so forth. So we're going to try to narrow it down and focus on 12 different topics today. Any questions, please hold them till the end. I'll be happy to answer them when we get there. You can put them in the chat box or again, the Q&A. And the chat isn't disabled. It should be there, or the Q&A box. I see you're saying that, Steve, but that's strange. It's not disabled on my side. Also, past webinars, we've been doing these for nearly 5 years. So our website, tullylawgroup.com, we have an events tab across the top. Click on that. We'll have future webinars, future events, speaking engagements, which of course we've started doing more of, and our past webinars. I'm going to talk about different topics today. If you want specifics, you can certainly reach out to us. We offer free consultations, or if you want to do it on your own and just get some more information, our website, go check out past webinars, and you can learn a little more detail and a little more depth there. So I'm going to share my screen again, and we're going to get started with our talk today. All right, so I'm sharing my screen. I'm going to assume it looks like it's up there. So here we are. 12 different strategies. And the way we're going to look at it is break it down into different categories. And again, if you've got questions, let me know at the end. So first and foremost, of course, we're going to talk about legal safeguards. And this is primarily going to be broken down into lifetime safeguards. And when we talk about that, what we're most concerned about is making sure that we have what are called backup decision makers, and ensuring that your parents, your loved ones, your grandparents, your spouses, yourself have in place backup decision makers are crucial. It is first and foremost the number one safeguard. What you'll see on your screen right now is what we call a durable modified power of attorney. Very simply, a power of attorney is where you can appoint one or two people generally to handle legal and financial matters for you. It is effective immediately. We prefer that. There is a version that is considered to be springing, which means it's not effective until a person actually becomes mentally incapacitated. We prefer not to use those versions of the documents because they could be harder to implement when we need to. So a durable modified power of attorney, most important planning document there is. Now, we have the word durable and we have the word modified there. Durable means that the document will remain valid even if the principal, the person that signed the document, should lose mental capacity in the future. So it's in essence strong enough to remain valid even if the person who appointed you can no longer make those decisions themselves. Historically, that wasn't the case. For example, go back several hundred years, I could appoint somebody to an agent to help me with something. But if I lost mental capacity, then that agent couldn't act on my behalf anymore. So that is a non-durable power of attorney. When we're talking about estate planning, aging, asset protection, tax strategies, etc., we want a durable power of attorney. The next clarifying word there I have, which is crucial, is this idea of modified. New York State has made the world of powers of attorney rather confusing. They've changed the law 3 times in the past 16 years. Always, however, the form itself has been rather simplified. It is a standard, what I'll call statutory short form, is what's written in the law itself. That statutory short form, which you can buy at Staples or LegalZoom or a number of different places, even some attorneys use just that, so word to the wise, you got to be careful who you go to. But that statutory short form is not, 100% is not sufficient for aging, estate planning, elder care, retirement accounts, trusts, long-term care, tax planning. It's not. It doesn't have those powers built into it. And a power of attorney is only as good as the powers that are written inside of it and approved by the principal and given to the agent. It's complicated. Unfortunately, we will sit with folks quite often where there is no power of attorney, or there is a power of attorney, but it is insufficient. It doesn't have the modifications. So you have to sit with an attorney that knows what they're doing in this world of elder care and in this world of estate planning. So number one, most important document, which is why we have it as number 1 here. Then we get into something similar, but on the healthcare side. Healthcare proxy decision maker, you are able to select one person at a time who can make decisions for your healthcare if you can't. So this one is not effective immediately. It has that springing effect built into it. So I can pick my wife, and my wife picked me, and I'm her decision maker if, God forbid, she can't make her own healthcare decisions, okay? And we pick successors with both of these documents. So you can pick a spouse, and then you can have a child as a backup, or a sibling, a parent, but you have a backup, a successor always. It's very prudent. We've updated clients' documents because they come to us with prior law firm documents and they don't have successors. You need a successor just in case, all right? Now in New York, what's interesting, and we fought for this for years, is if there is no healthcare proxy only, this only applies to the healthcare side of things, not the financial power of attorney side. So on the healthcare front, if there is a loss of capacity, we have in New York what's called the Family Healthcare Decisions Act. So there is a hierarchy of people that can actually make healthcare decisions for a person if they don't have the capacity to do it themselves. And spouse, for example, child, partner, etc., and the list goes on and on. That gets risky from our perspective, and we'd rather have the healthcare proxy in place so that you get to pick. If you have 3 children, they're all at the same level. So when you want the middle child or the youngest child, make sure you have a healthcare proxy in writing the right way that lists the people in order, okay? So that's safeguard number 1. And then we can get into more of the later in life and even passing on eventual perspective when it comes to estate planning. And of course, the last will and testament. Everybody, I shouldn't say everybody, but most everybody is familiar with the idea of a will. In fact, that's probably the number 1 statement we get when people call us. They'll say, okay, I need a will. And as I've said before on these webinars, that's fine. I'm glad people are calling and recognizing and acknowledging the need to get some planning done. There is a whole host of other planning that goes along with it. It's not just one document. An estate plan is not one document, especially the will, because at the end of the day, as important as a will is, and I'll talk about it, you don't ever want to use the will. You need a will. It has to have contingencies built into it. It has to be comprehensive. It has to provide for certain things happening here or there. But again, at the end of the day, you don't want the will to ever be utilized. A last will and testament, by definition, requires a court proceeding called probate. And that is a court proceeding to avoid, if you can, any type of asset that's owned in a person's name individually when they pass on must go through the will and go through probate. You're talking time delays, you're talking legal fees, you're talking complete lack of privacy, everything is public. You're talking about guardians being appointed for minor children or disabled children. You're talking about potential contests. If you're not leaving an asset to all of your children, you're talking about that child having to agree to the will being probated, even though they're not inheriting something. It just gets ugly very fast. So again, will is necessary, has to be comprehensive with contingencies, but you don't want to use it because you wish to avoid probate, that court proceeding. Oftentimes I'll get clients say, well, I have a will, it names a beneficiary. Doesn't that work? Can I avoid probate? And unfortunately, the answer is no. There are 3 ways to avoid probate: joint accounts, beneficiaries named on accounts, and trusts. All right, so specifically what I'm going to talk about now is the idea of a revocable living trust. There are different types of trusts, and the two big categories are revocable and irrevocable. For today's purposes, the revocable trust serves one primary purpose, which is to consolidate your assets so they can avoid probate when you pass away. So a revocable trust plan is ideal for many, many families, generally younger, all right, generally healthier, or we could be looking at an older client, but with significant assets. So there are certain times where a revocable trust becomes a very appropriate tool to help consolidate assets so that they can avoid that court proceeding. And the question we often get is, well, if I have a revocable trust in place, do I still need a will? And the answer is yes. Another way, when you ultimately pass on, to avoid probate is having beneficiaries named. So whether it's a bank account, an investment account, retirement account like an IRA, 401k, annuity, life insurance, name your beneficiaries, verify the beneficiaries, update the beneficiaries when something happens. Different life events is an opportunity to update the entire plan. Births, deaths, marriages, health issues, retirement. Look at and sit down with the attorney that helped you put it in place, or find somebody that's a little comprehensive and specializes in these type of things, and they can help you review and update as needed. Beneficiary designations, by definition, avoid probate. I had this question. I gave a talk to 50 folks the other day at a community over in Nassau County. And simple question, very common question. Well, if I have beneficiaries, why would I need a revocable trust? And quite honestly, the revocable trust is going to be a better tool than having beneficiaries. So, example, let's say you have a $300,000 mutual fund and you have your 3 children named as beneficiaries. Okay, parent passes on ultimately, that $300,000 account will go to the 3 children. Well, what happens if one of those 3 children is not healthy? What if they are on government benefits? What if they've suffered an illness or a stroke or something of that nature? What if, God forbid, they've passed away before you? Where is that third of this inheritance going? When you have a beneficiary form, it is a 1-page document. And the alternative is by taking that $300,000 account and transferring it into your revocable trust that you fully control and you can have full access to. But again, we're going to have contingencies built in there. So if God forbid a child is not healthy or a child has predeceased, we're able to address that in this revocable trust document so that we don't have to go to the courts. We don't have to deal with what are called guardians ad litem. Save time, save money, save stress, having built-in contingencies with a trust. All right. But they do work, beneficiary designations, but just not always the best way to look at it. Okay. Now, moving on to our third strategy, and I know I'm going to forget the numbers as we go, so I'll stop saying that eventually. The idea of long-term care planning. Basic planning, power of attorney, healthcare proxy, last will and testament, probate avoidance, that revocable trust, beneficiary forms, all out there, all important. A lot of it depends on the age of the client, the health of the client, and the assets of the client. All right. And the vast majority of people we sit with, not everybody, but a great chunk of them, have to address this idea of long-term care planning. And they have to do it because we might need a government program called Medicaid to help pay for the long-term care need. And we'll get into a little bit more as we go. And again, our website, tullylawgroup.com, has a whole host of webinars talking about these things. And again, we also offer free consultations so we can address these specifically to your facts and your situation. Long-term care planning must be addressed by clients. The reality is, if we have a long-term care need, which is best defined by needing assistance with what's called our activities of daily living, those ADLs, if you've heard that before. And there's 7 of them, and we do them every morning without thinking about it. We get out of bed, for example, that's called transferring. We then walk to the bathroom. We toilet, we bathe, we groom, we dress, and we eat. Those are the 7 activities of daily living. They're physical, functional activities. There is, of course, also a cognitive part, which deals with more what's called the instrumental activities of daily living. That could be driving or taking a bus, paying your bills, sorting your medications, housekeeping, cooking, and so forth. So long-term care planning is about physical as well as cognitive, all right? When we talk about protecting and safeguarding, however, there's a good amount of people, and Long Islanders and New Yorkers, that need to take advantage of what's called an irrevocable Medicaid trust. It has several different names: a Medicaid Asset Protection Trust, an irrevocable trust, a Medicaid trust. And again, our website has several different webinars talking about these, and our YouTube channel as well. Don't forget about that. Tully Law Group on YouTube. We have some specific videos just on these irrevocable trusts. When I sit with folks, I go through 10 different very clear points as to how these things operate. In essence, the word irrevocable is not desirable. A lot of people don't like that word, but by the time we are finished explaining how they operate and the control and the security that's kept and the flexibility that's built in, they're not that bad. All right. For example, we can protect a person's home considering the look back period. All right. Again, we can get into that a little bit today, but that's not the purpose of today. An irrevocable trust can protect your home and you're never going to notice the difference. You sleep in the same bed, you eat in the same kitchen, you pay the same mortgage, you have the same tax benefits. You can sell if you want to sell. There's really a lot of flexibility built into these irrevocable trusts. And again, they're appropriate and necessary when we're talking about the potential or option of using long-term care Medicaid to pay for our care needs in the future. It's not for everybody. Some folks are going to be able to utilize long-term care insurance to pay for their long-term care need. Not a lot of folks have long-term care insurance, but it's if you're able to afford it and have the health to obtain it, we want clients to consider that, because then you can purchase a pool of money that can pay for home care, that can pay for assisted living, and even pay for nursing homes. All right. It's valuable. It's just, again, not a lot of people have it in place. The unfortunate part of long-term care planning is what we see daily, which is this idea of a crisis. That means there's been no planning done whatsoever. There's been no protection done whatsoever. You do not want to be there in order to help safeguard your folks and your loved ones, your spouse, you want to undertake asset protection planning, long-term care planning in advance of actually needing the care. That's where this idea of a look-back period comes in. Gratefully in New York, and I'll share this briefly, gratefully in New York, we only have one look-back period, and that's a 5-year window for nursing home Medicaid only. Home care Medicaid, which is also called community Medicaid, still has 0 look back, okay? Crisis is a crisis, but there's abilities in a community home care setting to protect assets for that type of service without a look back period and without penalties, all right? So you want to avoid the crisis. You've heard me say this before. A crisis will always cost more. A crisis will always give you less options, and a crisis will always be more stressful. So why do you want that to happen to you or your family? You want more options. You want less cost. You want less stress, which means take care of these things in advance, all right? Now, speaking of stress and crisis, we go to our next point here, the idea of a guardianship. These are an unfortunate reality in our world, not just New York, it's throughout the nation. A guardianship is a court proceeding when, like we were just talking about, in a crisis, there is no proper power of attorney in place, no durable, modified power of attorney. It's missing its modifications. The concern here is if we have a gradual or a sudden loss of capacity, we could have dementia building for years, or we can have a sudden stroke. Unfortunately, these things happen in our world. And the reality is, if we don't have that proper, durable, modified power of attorney with all the proper modifications, then the family is going to get thrust into this guardianship proceeding. And it's not pretty. It's there because it has to be there. It's there because a lot of people don't take care of their affairs. They don't have the planning in place, and next thing you know, the capacity is gone. So for example, whether it's gradual or sudden, capacity is missing. We don't have capacity, parent does not have capacity, and we need home care. We need a nursing facility. So what do? Well, what we're looking at is going to a judge and saying, and it's under Article 81 of what's called the mental hygiene law, and you have to petition the court and say, Judge, my parent needs a guardian appointed of the person for healthcare decisions and guardian of the property for financial decisions because they can't do it themselves. So Judge, I'm asking you to declare my parent incompetent, all right? I'm asking you to strip them of their ability to make any decisions and any dealings with their assets, and I'm asking you to vest that authority in me and appoint me as the guardian. Difficult circumstance. The hearings aren't pretty most of the time. It's not something you want your loved one and your family to go through. And it gets even worse if there's a sibling standing next to me saying, you're not the right person to do it, I am. Now you've got two petitioners, a petitioner and a cross petitioner, both saying the other one shouldn't be the guardian. And on more than one occasion, we've seen it where the judge says, well, you know what? Neither of you will be the guardian. I'm going to pick an attorney who's going to bill hourly to be the guardian, or I'm going to pick another professional from a list to be the guardian. You don't ever want your family to get to this circumstance. And as much as I can say that and state that and request it and implore you to get the planning, the proper planning done, guardianship exists, and I'm grateful it's there because human nature doesn't deal with these issues very well. But you can avoid this. Safeguard your loved ones, safeguard your parents, talk to an elder care attorney such as ourselves, where we will get the proper documents and planning in place so your family doesn't have to endure this, okay? Moving on to the next one, advanced healthcare directives. And there's always, we talk about advanced directives, typically that involves healthcare decision-making. Some people consider the financial decision-making, but it's really about the living will and what I want. It can include the healthcare proxy, but we've already talked about that. For some people, it can include the power of attorney. We've already talked about that. So when we're talking about this safeguard, I'm going to suggest and recommend that your loved one have a written living will in place, okay? A living will, by definition, is a document. It's a statement. It does not appoint anybody to do anything. It's a statement that says, end of life. It says, if I'm ever in an irreversible condition, I do not want medical treatments to keep me alive artificially. So if I'm at that point of no return, then I do not want the machines. I do not want the ventilators. I do not want the respirators, the feeding tubes, the dialysis, but do give me pain relief. Okay? The court will honor, the hospital will honor evidence of a person's wishes, but a written living will is the cleanest way to say, okay, doc, mom didn't want this, and here we go, in writing, signed by her, witnessed. Short and sweet, okay? A 5-page living will can be complicated, all right? We want short and sweet. Something else. I don't like to see healthcare proxy documents and living wills merged. I say this every day of the week, probably several times a day. A healthcare proxy under the public health law is there to pick somebody to help you make decisions. Period. That's what the law says. That document can include HIPAA language for privacy release, but that's it. Every day of the week, we're seeing healthcare proxies that also include living will language. So it'll say, I pick my son as my healthcare agent, and if I'm ever in this condition, I don't want these life-sustaining measures, no heroic measures, etc. We don't like that. We don't want that. We want 2 separate documents. And I've been saying this for years, but literally 3 weeks ago, I'm sitting with a mom and a daughter. The mom was just in a Long Island hospital for a knee or a hip surgery procedure. And the doctor is there to start talking about the procedure and the risks. And the doctor says, oh, don't worry about that. You're a DNR. Do not resuscitate. That is a medical order that says, I don't want CPR if, God forbid, my heart stops during a procedure. That 73-year-old mom is not a DNR patient. She is a healthcare proxy where the attorney included living will language. And when that was taken in by the hospital, the nurse, the administrator there, they checked a box that said DNR because they saw the living will language. You don't want that to happen to you. So we always do 2 separate documents. So therefore, if you're going to the hospital, bring the healthcare proxy. You leave the living will at home. You don't break out those end-of-life discussions until it's time. All right, I hope that makes sense. Again, in this safeguard, in this strategy, and we're talking about safeguarding, there's another document to consider, and this is a doctor form. It's called a MOLST, M-O-L-S-T. It stands for Medical Orders for Life-Sustaining Treatment. Generally for folks that are 12 months or less. It's filled out with the healthcare provider. It talks about your end-of-life wishes. So it's a conversation. It's not just a 1-page form. It's a conversation about different scenarios and different types of treatments between you and your doctor. I will admit in the beginning I didn't like it. I've come to appreciate it and the benefit of it more as we go through this. But I will simply say also an activated, knowledgeable healthcare proxy agent is still going to be the best person and the best way for your healthcare decisions to be made. Living wills are good. Most forms are good. Healthcare proxies are essential, okay? So I hope that's helpful. Moving on. Close to my heart, this is what we do here at Tully Law Group. I'm not even going to say every day. I'm going to say every hour of every day. The idea of care advocacy. We are the only life care planning law firm downstate New York. Have a registered nurse on staff, have a geriatric social worker on staff, have a case manager on staff. Why? Because of this one. Talk about safeguarding your loved one. When your loved one needs long-term care, yes, you want an experienced elder law attorney, perhaps even a certified elder law attorney, as I have been for the last 22 years. But you also want assistance and guidance in dealing with the care issues, the navigating of the providers, coordinating the care, coordinating the benefits, advocating for your loved ones to make sure they get the best care they can, no matter where they are. Okay, and again, this is what we specialize in and have since 2009. When we talk about care advocacy, one of the first points is to Acknowledge and determine what's the level of care. And briefly, when I address this, it's all about, are we at home? Are we at assisted living, or are we at nursing home? There's different levels, and there's different permutations of that as well, but those are the primary three. Home care is where people want to receive their in-home is where people want to receive their care. People want to remain home. I do what I do for my own grandparents. A lot of you have heard that story before, but the reality is you want to stay home. Perhaps you want to make an assisted living your home. That's fine. That's your choice. Very rarely do people desire to move into a nursing home or a nursing facility. That's often the last resort. And gratefully, those numbers are coming down each and every year. But the level of care, let's stay home. Can we stay home? How do we provide the right amount of care so that person can be there safely? That's what we help do. That's what our care coordinators do. If you're preferring to work independent and not with our firm, then there are out there what are called geriatric care managers. I have ALCA written there as well. That stands for the Association of Life Care Advocates, I believe. They're independent case managers, care managers. We team up very well with them. They can be very much so in the trenches and help advocate and deal with home issues and doctor visits and so forth. So there's a way to get advocacy apart from a comprehensive law firm like ours. But if you are looking for everything under one roof, where you're going to have the attorneys and the advocates all working with the same goal, same perspective, and the same direction, then one of our elder care coordinators are going to be the best way to help your family protect the most assets, get the best care possible. That's what we're going to do. And our ECCs, as we call them, our elder care coordinators, are expert at navigating through this and these long-term care issues. Okay. So when you're dealing with a loved one that needs long-term care, you do not want to be the one to provide all the care yourself, and you don't want to be the one to advocate for the care and the best care, because you may not know what's out there. You don't know what you don't know, which is where you get the expertise and the assistance of people that have been down that road hundreds and maybe thousands of times before. Okay? Moving on to another way to help safeguard your loved one, and that's monitoring your financial accounts or their financial accounts respectfully. I've done other webinars on how to talk to folks about these types of issues, and it has to be out of genuine concern. It has to be respectful. It has to be perhaps over time. You don't just walk into mom's house and say, show me your checkbooks and your statements and your financial statements. That doesn't go over well, right? So it has to be done in a certain way and in an appropriate way so that it can be addressed in a beneficial way to ensure things are moving as they should. However, what we're talking about here is the idea of elder abuse and financial abuse. This happens a lot. When I used to teach at Malloy University, we'd spend a good amount of time talking about these risks. It happens by family, it happens by aides, it happens by caregivers, it happens by strangers. We've had clients scammed by the phone, we've had clients scammed by email, we'll talk about that in a bit. You have to be mindful and approach this very diligently and respectfully with your loved one, that things can happen where gift cards are being bought or wires are being sent through Western Union or bills are being paid multiple times because the agency keeps sending multiple bills. It's supposed to be once a month, but they send 3. So there's different ways to track, okay? Be mindful of that. One thing that we've done to remedy elder abuse in the past is we'll use a revocable trust or an irrevocable trust. And you can have somebody else as the trustee. Perhaps it's the child who's helping out the most, who's trusted. If that child's the trustee on the revocable trust account, they're the ones writing the checks. Perhaps not the senior that has been financially abused in the past. So this is a nice safeguard to have that type of oversight. Last year, I had a good friend of mine, Shannon Miller, who's a great elder law attorney in Florida, talk about financial abuse and what Florida does in order to combat it and to penalize and punish those that have perpetrated it. Unfortunately, New York does not have a very strong law or base of laws that deal with abuse, financial abuse, elder abuse, misappropriation of funds, etc. And we've tried to get district attorneys involved with $200,000-300,000 missing from clients' accounts, and it unfortunately doesn't go anywhere. So New York does need to do a better job in protecting their seniors. And if there's anybody out there listening that has the ability to do that, Florida has been a great example as far as how to lock down and get money back and protect seniors. All right, so that's, again, working on that one, but we're not there yet. Next topic, next safeguard is the idea of environmental safety, the surroundings. I'm not talking about the environment itself. I'm talking about where your loved one lives. And generally we call that aging in place. Aging in place, it's what most people want to do. There are certified aging in place counselors, advisors. You're talking about different types of home modifications. For example, widening doorways for a wheelchair, installing a roll-in shower, the grab bars, which is really the first step. As long as it's done right, it can help. You're looking at throw rugs not being around, extension cords not shooting across the hallways. Clients fall all the time. Loved ones fall all the time. And you don't want that. People are literally one fall away from something tragic happening, and then a whole sequence of events that can cause a downfall and the end. So you want to be very careful. You want the home to be as safe as possible. When we're working with a family on a life care side with the elder care issues, within 2 weeks of being engaged, 10 days often, one of our care coordinators is in the house looking at these issues from the start, okay? So it's not just remodeling the bathroom. There could be simpler things done, different lighting, for example. A very important way to help safeguard your loved ones. If your loved one chooses to live in an assisted living or requires the support of a nursing home, there are certain residential rights that they're entitled to. Every healthcare facility has a long-term care ombudsman listed with New York State. If there are concerns and you don't have an advocate, like I mentioned earlier, or if you don't have a firm like ours, then you're going to need to deal with the state and the county and the Department of Health and so forth yourself. When we're involved, we become the advocate. So if one of my care coordinators gets called by a client of ours because mom keeps falling and the facility isn't stopping it, or this is occurring or that is occurring, we're there. My social worker or nurse or case manager is showing up in that facility with the law firm card saying, I'm here, I'm watching her, and we're here to advocate for them. And that helps. All right. The squeaky wheel always gets the oil. And when you're talking about in facilities, you want to be a part of that squeaky wheel team, and you want professionals to also be a part of that. Moving on to the next safeguard, the next topic is the idea of social engagement. You want to be able to combat loneliness. That's where assisted livings are fantastic. It's one of the primary reasons folks move into assisted livings. But there are senior centers out there, and I think they're great, but I've had more than one senior tell me, no, those are for the old people. And I get that, but give it a shot. Senior centers, it's not just, there's social models, there's medical models, daycare, if you will. There's pool tables, there's card games, there's bingo, there's meals. It's a good socialization aspect that can help combat any type of isolation. Affinity groups or support groups. And when I say support groups, that could be based on different types of illnesses or grieving and what families and individuals have been through. Affinity groups, book clubs, pets, there's different ways, hiking clubs, there's different ways that you can, associate with people physically, socially, and of course online as well. Ultimately, we want to prevent isolation. Loneliness is an epidemic nationwide. It walk through a nursing home, it'll tear your heart out how many folks don't have visitors, and that's just the day you walk through it. It's like that every day. So there's a real epidemic with this. It leads to depression, it leads to other medical causes and issues. So focusing on the social engagement is important, very important. Medication management, another important topic. Why? Because medication can help keep our person, our loved one, healthy or healthier. But the problem becomes is if the doctor is speaking solely with your parent, perhaps there's a deficit cognitively or hearing or visually, I want clients, and we encourage family members to attend these doctor appointments with the permission of your loved one. So more eyes and more ears to listen. When I sit in a consultation with an 84-year-old husband, great, we'll do all we've got to do, and we'll be very careful to make sure he understands. But if he invites a child to be with him, that's helpful. It's more eyes and more ears, or even a friend, a spouse coming in together. The more people that hear what's happening, take notes, the better off the situation's going to be. I'm also going to recommend that you inventory the medication and you track it. Inventory it means, right, you're going to have a list. That list is helpful if you ever have to go to go in an ambulance or go to a hospital or a walk-in clinic. These are the medications my loved one is on. Tracking it means look in the cabinet, go to the kitchen, go to the bathroom, open the cabinet. What's the expiration dates? Are they taking all of one and none of another? Are they being used appropriately? Are they using those pill boxes? Are they being filled accurately? Are they skipping days? Are they taking the AM and the PM in the morning? So much is going on with this, and so much risk potentially with medications, and we know how important yet deadly medications can be. There are some companies that we recommend that will actually sell and transfer, deliver to the house blister packs. So it's all there. And there's even electronics that have become a part of it, as far as a light going off and it's time for this and it's time for that. Aging in place, safety, medications is a part of it. If somebody's in a facility again, generally you're going to have a nurse. Even in an assisted living facility, you're going to pay an extra amount over the room and board for a nurse to administer the medications. It's worth it. You don't want the medications to be mixed up, just as I've been sharing. Moving on, now we're almost done. The idea of technology. Smart homes are out there, and it's not just for people building new homes. We've seen this idea again of aging in place and again, safeguarding your folks. There are pads that can go on a bed and that can trigger and be recorded if they get out of bed at 3 in the morning. There are pads on the floor. There are cameras. There are sensors on cabinet doors where the medications are, so you can look on an app and know, when did dad open up that medication cabinet? Did he take them yet? Has he gotten out of bed? There is significant advancement when we're talking about technology and safe homes. Okay, so you can certainly look into that. There's a negative side to technology though, emails, cell phone scams. So it's not just the good stuff. The idea of phishing scams, getting an email, and I've got clients, it has nothing to do with age. They're getting emails just like we are. But what are they asking for? Right? Are you getting a text? I get spam texts all the time. This is Dr. So-and-so's office, or this is the UPS, or they sometimes say the IRS or Social Security, which they don't reach out, right? You got to be careful. But if somebody doesn't know that, and it asks for the Social Security number, the bank account number, there it goes. All right. It can be phone calls, cell phones, emails. We want to be mindful of that. All right. And again, we've done different types of webinars on this on the past. Last topic is the idea of just overall wellness. We've talked about physical, we've talked about financial, we've talked about the house, the residential. We all know there's an emotional component to aging and to wellness. We desire peace and stress-free living when we're in our 40s and 50s. We want that also later, if not more so. So the idea of conflict, the idea of tension within a family, the idea of aging and illness and mortality, all of that comes home to roost, if you will, when we're talking with our 70, 80, 90-year-old folks. So talk about it. Have conversations. It can be within one of those social groups. It can be within family. It can be within a faith community. There's been studies. Prayer and faith services are beneficial, not just to the social aspect, but just to aging in general, health and wellness in general. So consider these things, okay? So I hope that you found this to have been helpful. We covered a lot of different bullet points and things to address. Again, Tully Law Group website.com has more webinars that talk about these issues. as I've shared briefly, there's different ways to get help in these legal and financial and care issues. That's what we do every day. You have your traditional elder law firms, which will handle the legal and the financial, or what I call the documents and the dollars. There's a care component out there. If your loved one needs long-term care, is that going to be on you and the family to handle it? Or are you going to work with a firm that can actually incorporate that type of service and coordination and advocacy and crisis intervention into the service itself? Again, we've been doing it that way for 16 years and have helped hundreds, if not 1,000 families with their life care planning. It's the protection, it's the planning, it's the care advocacy together so that we can protect the most assets possible, help get Medicaid to pay if and when necessary for the care, and help your loved one get the best care possible. Okay. Again, I'm Brian Tully. Thank you for joining us for our webinar. Of course, we'll be back here in February, something maybe Valentine's related, we'll see. If you have questions, you can email me directly, Brian at, well, I got to update that. TullyElderLaw.com still works, but Tully Law Group works as well. So Brian at TullyElderLaw.com or Brian at TullyLawGroup.com. And there's our phone number, 631-424-2800. If there's any questions, I'll be happy to answer them now about the points that I've mentioned or anything else. Thank you all for sticking in. And yeah, we've actually gained a couple people as I was talking. So I appreciate you standing by. So if there's questions, you can go to the Q&A. I don't see any in there now, which is fine. You know where to find us as those questions arise. All right, so be well. And again, thank you for joining. Bye-bye.